I want to thank Judges Sullivan and McConnell for participating on the panel, and a special thanks to Judge McConnell, who actually raised this issue at our last Federal Bench Bar Committee meeting. And I think, Judge, you said that you were at the Conference of Judges, and someone reported that Chief Justice Roberts wanted all the districts to focus on the amendments because of their significance. So, listen. Before we begin, I have one shout out. Eric Bransky, are you here? Eric's a new member of the committee, and he was kind enough to do a summary of the rules, so thank you very much. Now, this seminar reminds me of the days when Judge Sullivan and I did the local rules seminar in the federal bar course. And that was some, I don't know, 5, 6+ years ago. So fast forward to today, Judge Sullivan is an esteemed magistrate judge, and I'm still trying to master these rules. So hopefully...
and so am I!
You all know that Judge Sullivan is an e-discovery aficionado, so she's going to take Rules 37 and Rule 34. Of course, Judge McConnell holds the Rule 16 conferences, so he's going to take Rule 16 and Rule 26, which now tells us what we can and what we're required to do before the Rule 16 conference. But remember, we also have our own local rules on Rule 16 and Rule 26. Now, that leaves me with those fascinating rules, Rule 1, 4, and 55. And then the trio of Rules 30, 31, and 33. And the only change to those rules is to confirm the change to the proportionality scope of discovery in Rule 26b1. And finally, Rule 84 and the appendix, the forms in the appendix have been abrogated. So what we thought we would do is go in order. I think as far as questions, maybe we can hold them until after each presentation. But look, this is very informal. If you have any burning questions, just raise your hand and we'll try to get you an answer. Okay, with that drum roll. Okay, we'll start at the beginning. Rule 1, it's actually one of my favorite rules, and it really provides the underpinning for all of the rules, and in particular the amendments that we're going to talk about this afternoon. It's also a really good rule to cite if you're dealing with difficult opposing counsel. So I think we all know that the current rule provides that the rules shall be construed and administered to secure the just, speedy, and inexpensive determination of every action and proceeding. The new rule now requires cooperation between the parties. And there's a theme to these amendments. You're going to be hearing about cooperation, reducing delay, reducing cost. Now, the commentary to the rule specifically provides that the amendment neither creates a new independent source of sanctions, nor does it abridge the scope of any other of these rules. However, it clearly emphasizes and requires the parties to share responsibility to use the rules in the same way that the court uses those rules, just, speedy, inexpensive determination. And in fact, the committee notes state, effective advocacy is consistent with and indeed depends upon cooperative and proportional use of procedure. And you're going to hear a lot about the use of proportionality as well. Now, when I look out at this crowd, obviously so many well-respected practitioners, and let me just make one side comment. We have a terrific bar, and we have a terrific bench, and I enjoy working with all of you. And maybe my comment is fueled by the fact that I have a few cases with counsel from out of state. And maybe it's an out-of-state thing, I don't know. But in the recent past, I've spent an inordinate amount of time responding to emails that come in at 11 o'clock at night, or responding to 7-page single-spaced letters. And in my humble opinion, that is neither just, speedy, nor, and it clearly is not inexpensive. So as far as the Rhode Island Bar, I would encourage you to keep on doing what you're doing. We really do have a good thing going here. So that takes us through Rule 1. My next rule is Rule 4. Rule 4 changes the time period to serve the summons and complaint from 120 days to 90 days. If service is not made within the 90-day period, the court must dismiss the action without prejudice against the defendant or order that service be made within a specified time. But if the plaintiff shows good cause for the failure, the court must extend the time for service to an appropriate period. As far as my practice, this really doesn't impact me because normally I'm representing the defendant. If I am representing the plaintiff, the defendant is normally a corporation with an agent for service, so service is made almost contemporaneous or shortly after the filing of the complaint. But I suppose if you're using the waiver of service, or if you have a defendant who's difficult to locate, just keep this time period in mind. And again, if you show good cause, the court must grant the extension. Now, one of the things we were talking about before we started is these rules are effective December 1 of this year. They clearly apply to cases filed after that date. But what about cases that are pending? And I think the answer is, and the judges can comment, but to the extent practicable, they apply to pending cases. But my understanding is there's been some discussion in the court regarding the impact of this rule. So if the complaint was filed before December 1, are we going to apply the 120 or the 90 days?
We have a determination that has not been passed on by Chief Judge Smith, so hang tight, it's not official yet, but the clerk's office will be noting that the time period for service and considering time period for services in pending cases will be under the old rule. Time period for cases filed on December 1 or after will be under the new rule. So from the clerk's office perspective, that's the default setting, assuming Judge Smith approves. I bet he will. If you need to change that for some reason, I think the rule contemplates that for good cause it can be altered. But the important difference for Rule 4 and its effective date from the effective date of all these other rules is that the other rules are applicable to pending cases with the sort of smushiness of feasible and work and injustice as potentially ways to make these rules not applicable to pending cases, but the default setting is they are applicable to pending cases, except our clerk's office is going to interpret Rule 4 as not.
Okay, thank you. Any questions or comments on Rules 1 and 4? Okay, at this time, let me turn it over to Judge McConnell, who's going to talk about the amendments to Rules 16 and 26. And Judge, one thing, I'm sure you'll comment about this, but I'm curious, under the amendments, the court can condition, before you file a discovery motion, you seek a conference with the court. Just curious on your reaction, if there's been any discussion with other members of the court, is that something we might see in the future? And also we'll be interested in comments from the folks attending the seminar.
Just switch this. Let me highlight the changes in Rule 16, and at the end you'll see the issue that Pat just raised queued up, and I can tell you what I think. The changes that they've made to Rule 16 and 26, which I'll talk about, in many ways are thematic more than they are practical. You'll see as we go through it, some of the language has merely been moved around to highlight it. Some of the language has been deleted in order to downplay it. There's some language that we all grew up with that they've taken away completely. So let's go through it. The Rule 16 conference, the court has tried to do, the amendments have tried to do two things. They want earlier and active judicial intervention in the management of cases. And they want the district judge and the magistrate judges more involved in managing the cases early on and throughout its litigation toward the idea of efficiency and lower cost. That's the theme that they put out in the changes that they made to Rule 16. So we'll go through each of the four parts of Rule 16. Some are more important than others. They have deleted the fact that a district judge or magistrate judge can hold their Rule 16 conference by telephone, mail, or other means, but they have pointed out that the court can hold the conference by telephone or other means if it wishes. So they deleted that section from Rule 16 while still allowing a court to do it, which is sort of funny to me because in the last month or so I've decided to hold the Rule 16 conferences by phone because it seemed much more convenient for the lawyers than dragging you over here for 10 minutes and whatnot. So I might have to revisit that. District courts can still hold the Rule 16 initial conference by phone if they want to, but the amendments have taken that specific provision granting them that power out. Second thing they did is somewhat meaningless to all of you, more important to our docket clerks. The Rule 16 conference now has to be held within 90 days after service or 60 days after appearance by the first defense attorney. So it just speeds up when they want us to get involved in setting forth a scheduling order under Rule 16. They specifically added 2 topics as suggested topics within Rule 16 scheduling conference. They've recommended that we discuss the issue of preservation of electronically stored information, which Pat will talk, Magistrate Judge Sullivan will talk more about later, but they've asked district courts to deal with it right up front at the Rule 16. And the second is whether we can get agreements on Federal Rule of Evidence 502, which is the disclosure, inadvertent disclosure of privileged materials. So they've added 2 topics that they recommend we deal with at Rule 16 conferences. Again, none mandatory. It's what I tell everyone at CLEs, know your judge, know what they, it's going to be up to her or him what they want to deal with, but the rule amendments have recommended that those 2 topics be added to it. The one that's, that Pat highlighted a few minutes ago that we don't know the answer from this district court is they have encouraged courts to require, as part of their initial orders, that, that you get permission before filing discovery motions. So I call it the Judge Smith rule. If you know from our standard order, he requires you to have a court conference before you can file a Rule 56 summary judgment motion. The new amendment to Rule 16 encourages courts to require conferences with the court before motions are filed. I have no idea how we'll deal with that. I have no idea how we'll deal with it individually. My personal practice has been to encourage lawyers and give them the opportunity to just call me with discovery disputes so we can get through them easily. Some people take me up on that, others haven't. I've never required a conference before a filing. I assume that this will be queued up and the court will look at it in the course of looking at amendments to our local rules within the next year.
Judge, could I just ask, I'm just curious, and not to bind anyone, but just to show our hands of people who would be in favor of a conference as a requirement, a conference with the court before filing a discovery motion.
Yeah, my thought was, now that it's in Rule 16, if in an individual case, a party believes that there's going to be real abuse of, motions to compel, and it's going to be constant, it's going to be troublesome, it might be something that you suggest to the court as part of what goes into your individualized case, rather than something that we as judges impose as a knee-jerk matter.
Makes sense. Since I've gotten here, tried to go out and market and sell the federal court as a user-friendly place to file your lawsuits, and I'll continue to do that and tell you that a number of issues that arise like this within the individual nature of your case can be brought to a magistrate judge or district court judge's attention, and you can get that kind of relief. I mean, a little example is how some healthcare providers are requiring unaccepting subpoenas as a court order for privacy violations on medical records. And so you have to file a motion, or there's a motion for protective order, you have to wait for an objection, it has to be heard. When those are brought to my attention, we deal with those in a quick phone call and get through them in a day. Just an example of the ability we have to cut through what may be needless red tape in areas that might not otherwise matter.
I agree, if that option's available, I think it could be very helpful to the parties and could resolve the issues without a lot of motions and exhibits and get it done quickly.
Clearly, whoever writes the amendments to the rules believe that courts should adopt that requirement. The big changes that I talk about are in fact in many ways not big changes, but big focus in many ways, and that is as to Rule 26, at least as I perceive it. And what they've basically done is added what has been euphemistically referred to as the proportionality requirement. The reality is that the proportionality requirement factors that are now moved up to Rule 26B1 were contained in Rule 26B2C3. And what they did was they took those factors and they added to it. I'll show you that in a second. They basically took that out of the protective order subsection and they moved it up into the initial idea of what the scope of discovery is. And they've made two elements relevant for determining what falls within the scope of discovery, unlike we were all taught in law school. So used to be material that was relevant or material that was likely to lead to the discovery of admissible evidence. Now it's twofold. The first is relevance, stays and remain, and the second they've added, the second element is that the discovery must be proportional to the needs of the case. And then they elevate 4 factors that were hidden down further in the rule, and they've added a 5th factor to it. So in determining what is proportional to the case, the scope of discovery, one determining that, in this case the court or the parties, are to look at the importance of the issues at stake, the amount in controversy. They've added the parties' relative access to relevant information. We'll talk about that one in a second. There's been some commentary about what a number of these mean. The parties' resources, the importance of discovery and resolving the issue, and the burden or expense outweighing the likely benefit from it. So right up front, in terms of scope of discovery, they now add proportionality to it. There is some commentary that's gone out that said the 5th factor, the 6th factor they've added, the parties' relative access was added to give plaintiffs that bring suits more of an argument that further discovery should be allowed than might otherwise be under proportionality analysis if they don't have access to the information the way a defendant would when they are sued. So they've added the factor on proportionality, that the relative access to the information, it can be included in the proportionality analysis. Taking away that one, it's an economic balancing test in many ways that one could argue one way or the other benefits plaintiffs or defendants in a particular case, and we have no case law, we have no practice, we don't know how individual judges will play it out. But what courts will look at now is issues right up front about scope of discovery. Well, let me jump ahead and show you, because it will make more sense. What they deleted, no longer within scope of discovery, is reasonably calculated to lead to the discovery of admissible evidence. That catchphrase used to be where oftentimes litigants would go. Some on one side would call it allowed fishing expeditions. On the other side, it allowed people would argue it allowed them to do their jobs as litigators, to delve into an issue properly. That has been deleted. Again, I think we all grew up with that phrase, or thinking that's the phrase. I know every discovery case I've ever had, the proponent of the discovery has argued it to me. The commentators on the amendment claim that it's semantics and emphasis, that in fact one can still make that argument because they have added the definitive statement that the scope of the evidence, the discovery sought does not have to be admissible. So they've added the definitive statement that it does not have to be admissible evidence for it to be discoverable, which is somewhat similar to what people argued under the old line. But they took out that line to de-emphasize the fact that they don't intend that phrase to be a catch-all for fishing expeditions. So again now, when you're looking at proportionality, when you're looking at the scope of discovery from either end, you're now forced to do this balancing act. And we probably don't have enough time, nor do we have enough direction to see where that's going to go or how it's going to play out. But I will tell you that depending on how courts read it and how judges read it and appellate courts apply it, could severely restrict the amount of discovery that goes on in cases, particularly when combined with some of the limitations that have been put on the filings of class actions and whatnot. The second big amendment to Rule 26 has to do with costs. They have added the term that is part of a protective order. Courts can now do an allocation of expenses on the production of material. The advisory rule says, and I note this for anyone that wants to run and get costs, that they still anticipate that the person providing the discovery will bear the cost of the production. That it will not fall on the person requesting the discovery, but the burden will fall on the person producing it, and they don't anticipate the adding of the allocation of expenses provision to the protective order section to change that dynamic at all. But they did add that. The third major amendment is one of those, I don't know, somewhat meaningless amendments in my humble opinion, and that has to do with request for production. You can now serve a request for production prior to the Rule 16 conference. Sounds good, get discovery going and started. However, the recipient of the request doesn't have to answer it until 30 days after the Rule 16 conference. So they have put forward the time when you can file the request, but they have left in place the time for answering it. I don't understand the logic of that, other than if you want to give the other party notice of the scope of discovery on production of documents that you're going to do so that it could be dealt with at the Rule 16 conference. That may be one reason, but it doesn't do anything in many ways to produce earlier production than the rules otherwise provide for. Rule 16 and 26.
All right. Any questions on Rule 16 and 26?
I don't want to assume, but the proportionality test, will that apply to pending cases and pending motions or future motions?
Good question.
According to the, applicability, it's applicable to pending if feasible and in the interest of justice. If a motion was prepared prior to December 1st, this will be a brief period of exquisite chaos. And the objection and the hearing is post-December 1st. There may very well be a lively discussion of whether the rule should be applied. I actually have an exemplar of that currently pending before me. Motion already filed, objection not yet received, hearing won't happen until after I get back from my vacation, which will be after December 1st. So I don't know what will happen, because there's no doubt that this rule will target the discussion during that argument.
The rule itself clearly applies to pending cases as of December 1st, with the carve-out that for efficiency and justice, it cannot apply. So the default rule is it applies. If you want to argue that it doesn't apply, they've given you a couple of ways to argue.
But my tendency will be to be guided by the new rule and not the old rule, if there's a material difference.
Which I might argue there is none.
Exactly. Arguably, there is no difference. This is just focus, not change.
Okay, any other questions? Okay, Judge Sullivan, rules 37 and 34. All right, maybe it's quicker. You do.
I'm going to start at Rule 34. That's my assignment. There actually are minimal related changes to some of the other rules. And in the interest of being able to see what on earth is up there that you can see, I'll just be lazy and stand here. First of all, the changes to Rule 34 are somewhat boring. I'll go through them fairly quickly. They essentially are bringing 34 into conformity with another rule change that's boring and uninteresting, and memorializing what I would call existing practice. So the first change is to take into account the peculiar ability that everyone now has to file their request for production before the 26F and before the Rule 16, but you still don't get the responses until after. So this is simply memorializing that in Rule 34. Interestingly, and I don't know why, the only discovery tool that was changed was Rule 34 request for production. Interrogatories, depositions remain the same in terms of you can't initiate them except in very narrow circumstances until after the parties have had the 26F and the Rule 16 has taken place. So that is boring A+. The second change I think is actually a helpful memorialization of existing practice. First of all, the requirement for specificity in the grounds for objecting is really has already been threaded through the rules. It's now stated very firmly and clearly. It's certainly something in terms of my approach to motions to compel. I want to see that level of specificity, and if the meet and confer hasn't brought the parties to the point of knowing exactly what's objected to, what's not objected to, and as to what's not objected to, what are you doing? It's now clearly embodied in the rules. The other thing that I think is almost humorous is that the rules now require what has been the reality since the Xerox machine was tightened up about 30 years ago. And instead of talking about permitting inspection, it says you'll produce copies. So that the response now may state what 90% of responses already do state, that the responder will produce copies of either the documents themselves or of the electronically stored information, and will not respond by permitting inspection. I've been practicing before going on the bench for 35 years, and I don't think I ever went to an inspection. So this is kind of a silly rule. The other thing that I think is useful to require, again, something that really reflects best practice, is the very last sentence there, which is that you can't just say, I'm going to produce the documents, ha, good luck, when you see them, who knows. In fact, you have to say when you're going to provide them, and then you have to provide them when you said you were going to provide them. So that's a change. It could be a trap for the unwary, is that you now must, as the responder, either produce when you're told to produce by the request. Has anyone ever heard of that happening? Don't bother to raise your hand. Or you specify the time when you will produce the documents in your response. Will eliminate, frankly, I think, a lot of motion practice. The other one that I am very grateful to see, which I think will eliminate a lot of motion practice, is the new requirement that the objection has to say whether responsive materials are being withheld. So having a set of canned objections with no indication of whether or not those objections are actually shielding documents or not is no longer acceptable under the rules. If you end up coming into court on a motion to compel, as a practical matter, it isn't acceptable. You will walk out with the requirement that you clearly indicate what's being withheld, And I actually remember very long ago Judge Torres imposing sanctions on somebody for not abiding by something that was not in the rules until December 1st of 2015. But here it is. So that's, again, important. Basically, I think what this rule is doing is consistent with that Rule 1 theme of cooperation, embedding in the rules some of the things that had commonly been leading to the need for motion practice in connection with discovery. Now the rules are crisp and clear. You got to be clear. You got to say what you're objecting to with specificity. You got to say what's to be produced and what's being covered up. And as to what's being produced, you got to say when. And which eliminates, I would say, about 40% of what I see coming before me in the unnecessary part of motions to compel. So this is a useful cleanup. So let's jump to Rule 37, which has two changes. The first one I would call in the category of boring. It basically, remember the Rule 34 now says you produce the documents as opposed to making them available for inspection. This is just bringing Rule 37 into conformity with Rule 34. Dull, dull, dull. But then, this is fairly blockbuster. This is a huge change, a sea change, and potentially a big change affecting practitioners in this district. Basically, what's happening here is a safe harbor that I have never heard mentioned ever in the history of the world is being eliminated, but instead, what is now incorporated into the rule is a body of case law that has grown up principally in the Second Circuit, the Zubilate line of decisions. Second Circuit has been weighing in. There are some decisions by Judge Grimm in the District of Maryland dealing with what is the obligation of a party to preserve evidence, what is the obligation, what is the risk of that party if the evidence is not prepared, has not preserved the records, and what does the court do if electronic information that could have been available is no longer available. The rule was developed, interestingly, at the Duke Conference, where all of these rules were noodled over, by a subcommittee that was chaired by Judge Grimm, who's also the author of some of the most interesting decisions in this area. And what they essentially have done is they've taken all of that case law, starting with Judge Scheinland's first Zubilate decision, distilled it down to some tight little words, eliminates some of the harsher things that had worked its way into some of the cases, particularly in the district court in the Second Circuit, and have now, in effect, legislated this approach. So it's no longer Second Circuit law, maybe it's applicable, maybe it's not, who cares? It is in the rule. So let me kind of go through it in pieces. It's a little bit complicated. The first thing that is very important is the reference to preservation of the electronically stored information. You'll recall back at the Rule 16 conference, the preservation of records is now a suggested topic to be covered at the Rule 16 conference. There is case law in the Second Circuit saying that if you have not, as counsel, prepared a written preservation directive to your client, and then there's lost electronically stored information, that the court will assume that that's intentional and jump right down to the what's going to be on the next slide, which is sanctions. That has not been adopted, so that's important. The framers of this rule have essentially now legislated the requirement that there's a point where a duty to preserve electronically stored information attaches, That point may very well precede the filing of the complaint. It's basically, there's lots of cases on when does that point of preservation attach in a specific case, but there's a duty to begin to take steps to preserve, and this is applicable to plaintiffs and defendants. Certainly large corporations are very aware of this duty and are doing things about it, but plaintiffs representing individuals need to be aware of this duty. I can't tell you how many times, oh, I got a new cell phone. Oh, I'm Tom Brady and I destroyed my old cell phone. You can't do that anymore as a plaintiff. You've got to recognize that the minute the case comes to your attention, before you've even filed your complaint, you may very well have an affirmative duty to preserve the electronically stored information that's on the cell phone, on the Facebook, or wherever else that information may be sitting. So that first phrase legislates that duty. The next thing we look at is if the electronically stored information is no longer available, it's gone because that duty was not adhered to by counsel. Because the parties failed to take reasonable steps. So what are the reasonable steps? The case law in the Second Circuit develops that. Certainly, there's an obligation on the part of counsel to advise. There are cases in the Second Circuit where the sanctions are imposed on counsel and not on client because the counsel failed to advise the client to preserve. But when the preservation directive is made by the attorney, the client is made aware you've got to keep this, and the client needs to take reasonable steps to preserve. And, so we don't launch into part 2 where we start talking about sanctions. The electronically stored information can't be replaced or restored. So if the lost information exists entirely in the form of emails received by the recipient, even though the sender has flushed the cell phone down the toilet, we don't go any further. We stop right here. So the electronically stored information has to have been lost because of the failure to take reasonable steps to preserve electronically stored information that was in existence at the time that that duty to preserve came into effect. So what happens? The first part of this rule deals with situations where there is not a finding by the court that the party that lost the information acted with intent to deprive the other party. So, part 1 is what to do when we do not have intent. And as I mentioned a moment ago, in the Second Circuit, there is district court case law saying that the lack of a written preservation order is presumptive evidence of intent. That, I believe, has been rejected, but we'll see. So, part 1 says, if there is a finding of prejudice, so the party seeking the electronically stored information has to demonstrate, you can't demonstrate intent, you have to demonstrate that you've been prejudiced by the loss of information that was in existence but is no longer around after the attachment of the duty to preserve. So if there's a finding of prejudice, the court then takes whatever actions are necessary to cure the actual prejudice. So it really places a burden on the party seeking the information to demonstrate prejudice. The court then has all the tools available, but the tool that is chosen by the court is what is no more than necessary. That may mean a presumption of unfavorability for lost information, but it may mean a piece of the case doesn't go to the jury, that it can't be developed. So, but the court's directive by the rule is to be laser focused on what's the finding of prejudice and what's necessary to cure that. However, part 2, if there is a finding that the party that failed to preserve acted with intent to deprive the other party of the information, then the court may presume unfavorability, instruct the jury, dismiss the action or enter a default judgment. Very strong sanctions. And what's significant is that the finding of intent eliminates the need for a finding of prejudice. There's an or between parts 1 and 2. So the fact that the loss of electronically stored information has not caused any prejudice, again, that scenario where the sender of the emails flushes the cell phone down the toilet, but the recipient has all of them still nicely stored. In that circumstance, you still are exposed to sanctions because of the finding of intentionality. This is brand new for this district, and I think particularly for people on the plaintiff's side, where the duty to preserve attaches before the complaint is filed, and you're frequently dealing with individuals who may not think that their cell phones and tablets are things that they need to talk to their lawyer about when they first bring the case to the lawyer and talk about, the fact that I've been injured and I want you to file a case. In fact, at that moment, that conversation needs to take place because the risks are very serious and very new in terms of applicability, not just in this district, but in the circuit. There has not been a robust body of case law developing in the First Circuit on this issue. It's been developing elsewhere, but it's now in the rule.
Can I ask you, could one assume that absent a finding of intent, that the presumption or the instruction to the jury wouldn't be applicable as a sanction for the loss by the fact that those are specifically sanctions under the intent provision?
I would actually read it differently. I would read it that if there's a finding, no intent, but there has to be a finding of prejudice. If there's no intent and no prejudice, we're done. If there's prejudice but no intent, then the court has to figure out how do we fix the prejudice. And a way to fix prejudice is to presume, instruct. Those are all tools that the court has. Even though they're found under the intent. Even though they're found under the second provision. The point is that if there's a finding of intent, the rules are not directing the court to be laser focused on cure. It's punishing, and those are the punishments that are available. Under Part 1, it's what's necessary to cure, and the courts has lots of tools, but those are some of the tools, and I think those tools could be wielded in those circumstances, but only if necessary to cure. Questions?
So take the bizarre scenario that you have a client that has a computer with a hard drive and they intend to make that inaccessible. They take a hammer and they beat the computer to death, but they don't realize that they haven't hurt the hard drive at all. So you can recover the hard drive and recover all the information, but here you have this computer that's been beat to death, so to speak. So the intent's obvious.
So if you can recover it, we never go to the next page.
So in your email example, if the recipient still has all those emails, you can recover them.
Right.
Even though I dumped my email account so that I didn't have it.
I mean, yes.
Yeah, I'd like to go back to Rule 34.
Boring!
I really like this idea that I'm objecting, but there are no documents, so it doesn't make a difference. How does that mix with the duty to supplement? I stated this objection, I don't have any documents, and then some documents come in for which the objection applies. Do I have to then go back and say, oh, I do have documents now, for which that objection makes a difference?
I think you do. I think you do. I mean, if you find relevant documents that were responsive to a request but for an objection, and you didn't know about them at the time you asserted the objection, but then you find out about them later. I mean, at any time you find a new cohort of responsive documents responsive to a discovery request, you got to stop the music look at them, see whether they're responsive, and then make a determination about supplementation. Your supplementation in your hypothetical is going to be responsive documents are being withheld on grounds of the following objections. That's my supplement.
So would the duty to supplement require a party to go back and update their objection to state whether they are withholding documents or not?
Well, I think when you supplement, you'll object.
But if the objection was filed before December 1st,
Sounds like the injustice exception will say. Sir?
Judge, the objection itself, does it just have to be as you stated, or are they looking for almost like a relevance now? Is that what we're...
Oh, no. It's really what, when the argument on the motion to compel comes before me, I say, all right, come on. The question is, you can say objection, overbroad, and then you don't just stop. You continue and say, the relevant documents are all located in the main plant. The subsidiaries have documents, they're not relevant, and I'm not searching. So now the recipient knows if there's relevant documents, if the theory of the case actually would call for documents at the locations that weren't searched, that then gives you a right, appropriate thing to argue about. But if all you say is overbroad, the recipient has no idea. And what ends up happening in real time is that discrepancy emerges during the argument on the motion to compel, and I end up sending you away saying, tell us the scope of your objection and what you're objecting to and what you're not objecting to on overbreadth, and whether there's documents that are being protected or not, and then see if you really have a dispute, because we don't know if you have a dispute until the objector is clear. Sir?
Getting back to Judge McConnell's question, in sanctions, if there's prejudice but no intent, how is the adverse inference going to be possible given that word only?
I'm not sure.
It says
Let's
only
see.
upon finding.
Yeah,
See, I read it.
yeah,
that
only
it
upon
means
finding,
only-
yeah,
Only come into play
Mhm.
if there's a finding.
yeah,
of intent.
yeah. Well, I think the problem is that interpretation was stripped from the court. If the way to, if the measure that is necessary to cure the prejudice is a presumption that the lost information was unfavorable, that's the only way to cure the prejudice, then I think that is within the power of the court. It's not precluded by the rule. I think we're all going to find out.
We are just at 1:30, and when the hour ends. Just a couple logistics before Pat closes. There's an incredibly handy handout that we obviously didn't have enough copies for. That lists the exact changes, old, new, with commentary on it. It's going to be placed on the court's website, so you'll have access to it, so don't worry about not picking one up. And consistent with what we're going to be doing on into the future, this has been videoed and will be put up on the website too, so if there's something specific that one of us said that you want to go back and take a look at, you cannot submit it in a brief to us, change our mind, but you can, for refreshing your recollection, it should be up relatively shortly, but we're hoping to put more and more of the activities of the court up on video. So with those two logistics. Pat?
Okay, there's one final amendment. It's in the boring category with respect to Rule 55, so I'll leave you with the written materials. Thanks to Judge Sullivan, Judge McConnell, and thanks to everyone for the session.